Hey, just dropping in to say we're now on Patreon. If you want to support the project, head on over to patreon.com/legalistening, where you can unlock some fun bonus content with me, Zach, and some special guests. Thanks so much for all your support. Hey, welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey there, just me. Today I'm going to bring you the concurring reasons of Justice Moldaver and Rowe in The Queen and Goldfinch. If you want to hear the majority's opinion or hear what me and Zach thought about the case, head on over to the previous episode. Enjoy! The reasons of Justices Moldaver and Rowe were delivered by Justice Moldaver. Part 1. Overview. This case raises the difficult yet important issue of whether, and if so, to what extent, evidence of an ongoing sexual relationship between the accused and the complainant is admissible in a sexual assault trial. The complainant in this case alleges that on May 28, 2014, the appellant, Patrick John Goldfinch, sexually assaulted her in his home. The incident resulted in Mr. Goldfinch being charged with both assault and sexual assault. Mr. Goldfinch maintained his innocence, claiming that the sexual activity in question was consensual. At trial, Mr. Goldfinch applied under Section 276.1 of the Criminal Code to adduce evidence that at the time of the alleged sexual assault, he and the complainant were in a friends with benefits relationship that involved occasional sex. The Crown opposed the admission of this evidence. Following a voir dire, the trial judge ruled that the evidence was admissible for the dual purposes of providing context to the events in question and avoiding an erroneous misapprehension on the part of the jury that Mr. Goldfinch and the complainant were platonic friends. The trial ended with the jury acquitting Mr. Goldfinch of both assault and sexual assault. The Crown appealed Mr. Goldfinch's acquittals to the Alberta Court of Appeal. A majority of that court overturned the acquittals, holding that the trial judge erred in admitting evidence of the nature of Mr. Goldfinch's relationship with the complainant, friends with benefits, at the time of the alleged assault. In the majority's view, this evidence was inadmissible because it did nothing more than advance one of the twin myths prohibited by Section 276 sub 1, namely that the complainant was more likely to have consented on the night in question because she had previously engaged in sex with Mr. Goldfinch. Justice Berger dissented. In his view, the impugned evidence was admissible under Section 276 sub 2 because it was integral to Mr. Goldfinch's ability to make full answer and defense. Mr. Goldfinch now appeals to this court as of right. The Section 276 regime is sometimes viewed as a zero-sum game, pitting the rights of the complainant against those of the accused. But in my respectful view, this is a mischaracterization. The Section 276 regime is designed to respect and preserve the rights of both complainants and accused persons by excluding evidence which would undermine the legitimacy of our criminal justice system and inhibit the search for truth, while allowing for the admission of evidence which would enhance the legitimacy of our criminal justice system and promote the search for truth. In this way, the regime seeks to promote the integrity of the trial process as a whole, a concept that is essential to the public's faith in the criminal justice system. In pursuing this objective, the Section 276 regime operates in a step-by-step manner. From the accused's initial application under Section 276.1 to the final limiting instruction required by Section 276 sub 4, the Section 276 regime establishes a rigorous, multi-step process through which sexual activity evidence adduced by or on behalf of the accused must be carefully vetted and winnowed down to its essentials. To make its way into evidence at trial, such evidence must withstand careful scrutiny at each stage of the process. As I will explain, for sexual activity evidence to be admitted under Section 276 sub 2, the accused must demonstrate, at a minimum, that the evidence goes to a legitimate aspect of his defense and is integral to his ability to make full answer and defense. This requires that the accused be able to identify specific facts or issues relating to his defense that can be properly understood and resolved by the trier of fact only if reference is made to the sexual activity evidence in question. Further, to the extent sexual activity evidence is ultimately admitted, the trial judge must explain to the jury, in clear and precise terms, the uses for which the evidence may and may not be used. Finally, all trial participants, including the trial judge, Crown and defense counsel, and witnesses, must hew to the specific legitimate purpose for which the evidence has been admitted, without expanding the scope of the ruling or using the admissible evidence for inadmissible purposes. This is essential to preserving not only the rights of the accused and the complainant, but also the integrity of the trial process as a whole. In the case at hand, for reasons that follow, I am respectfully of the view that the trial judge erred in admitting the friends with benefits evidence under Section 276, having particular regard to the manifest deficiencies in Mr. Goldfinch's application to introduce the evidence. Furthermore, the improper admission of this evidence for the broad purpose of providing context led to a significant and highly prejudicial broadening of the sexual activity evidence at trial. This, in my view, might reasonably have had a material bearing on Mr. Goldfinch's acquittal. I would therefore dismiss the appeal. Part 2. Facts and decisions below. My colleague Justice Karakatsanis has summarized the facts and decisions below in her reasons, and I see no need to replicate her work. I will therefore proceed directly to the issues on appeal. Part 3. Issues. This appeal raises two issues. 1. Did the trial judge err in admitting under Section 276 evidence of the sexual nature of Mr. Goldfinch's relationship with the complainant at the time of the alleged sexual assault? If so, could this error reasonably be thought to have had a material bearing on Mr. Goldfinch's acquittal, such that a new trial is warranted? Part 4. Analysis. Before commencing my analysis, I would point out that my colleague Justice Karakatsanis and I align on many, if not most, of the core principles governing the Section 276 regime. The main point that separates us is that while my colleague concludes that the sexual activity evidence in question, the existence of a friends with benefits relationship, is categorically barred from being admitted under Section 276, I take a more nuanced approach. In particular, as I will explain at paragraphs 121 to 125 of these reasons, I would leave open the question of whether the presiding judge at the new trial might, if presented with a properly framed 276.1 application, admit the evidence after applying the test and weighing the factors set out in Section 276 sub 2 and sub 3. Having foreshadowed these points, I turn to my analysis. Subpart A. Overview of the Section 276 regime. Section 276 of the Code governs the admissibility of evidence of the complainant's sexual activity, other than that which forms the subject matter of the charge. In these reasons, I will refer to such evidence simply as sexual activity evidence. As I will explain, the various components of the Section 276 regime work in harmony to root out stereotypical and discriminatory reasoning and preserve the integrity of the trial process. Section 276 sub 1 reads, Evidence of complainant's sexual activity. 276 sub 1. In proceedings in respect of an offense under Section 151, 152, 153, 153.1, 155, or 159, subsection 160 sub 2 or sub 3, or Section 170, 171, 172, 173, 271, 272, or 273, evidence that the complainant has engaged in sexual activity, whether with the accused or with any other person, is not admissible to support an inference that, by reason of the sexual nature of that activity, the complainant A is more likely to have consented to the sexual activity that forms the subject matter of the charge, or B is less worthy of belief. Stated succinctly, this provision prohibits the use of sexual activity evidence to support one of the twin myths identified by this court in Seaboyer. In doing so, it gives effect to the principle that these myths are simply not relevant at trial and can severely distort the trial process. Accordingly, if the sole purpose for which sexual activity evidence is being proffered is to support either one of the twin myths, it will be ruled inadmissible under Section 276 sub 1. It is as simple as that. But that does not mean sexual activity evidence will always be ruled inadmissible. Where the accused can identify a legitimate purpose for introducing the evidence, one that does not involve twin myth reasoning, admission remains a possibility. In this regard, Section 276 sub 2 provides that while sexual activity evidence adduced by or on behalf of the accused is presumptively inadmissible, regardless of the purpose for which it is proffered, such evidence may be admitted where it satisfies a three-part test. In undertaking the analysis required by Section 276 sub 2, the trial judge tasked with making a ruling on admissibility must take into account the factors listed in Section 276 sub 3. Thus, sexual activity evidence adduced by or on behalf of the accused that could potentially implicate one of the twin myths may nonetheless be admitted for a separate, legitimate purpose where it satisfies the test set out in Section 276 sub 2 and sub 3. But before sexual activity evidence can be admitted under Section 276 sub 2, the accused must file an application under Section 276.1. This application must be made in writing and must set out a. detailed particulars of the evidence that the accused seeks to adduce, and b. the relevance of that evidence to an issue at trial. Where the judge is satisfied that a. the application was made in accordance with Section 276.1 sub 2, b. certain filing requirements have been met, and c. the evidence sought to be adduced is capable of being admissible under Section 276 sub 2, then he or she shall hold a voir dire, held outside the presence of the jury and the public, to determine whether the evidence is admissible under Section 276 sub 2. However, if the judge is not satisfied that each of these three requirements has been met, then he or she may dismiss the application without more. Thus, for example, where a written application under Section 276.1 does not satisfy the judge that the evidence sought to be adduced is relevant to an issue at trial, it can be dismissed without holding a voir dire. While the parties in this case have not focused their submissions on the Section 276.1 requirements, these requirements and the consequences for failing to meet them should be kept in mind going forward. If the accused written application survives scrutiny, then the process moves to the voir dire stage and the court's attention shifts to Section 276 sub 2. In my view, to satisfy the relevance requirement under Section 276 sub 2 sub b, the accused must demonstrate that the evidence goes to a legitimate aspect of his defense and is integral to his ability to make full answer and defense. This requires that the accused be able to identify specific facts or issues relating to his defense that can be properly understood and resolved by the trier of fact only if reference is made to the sexual activity evidence in question. In articulating these specific facts or issues, simply citing the need to provide greater context or a fuller narrative will not suffice. Indeed, if this were enough to justify the admission of sexual activity evidence, then the Section 276 regime would be reduced to a mere statutory speed bump along the way to admission. Furthermore, the requirement that the evidence be integral to the accused's ability to make full answer and defense means that even if the evidence can be linked to specific facts or issues relating to the accused's defense, admission is not guaranteed. There may be cases in which the evidence, while relevant to specific facts or issues relating to the accused's defense, bears only marginally on it. In such cases, the trial judge may, in his or her discretion, exclude the evidence on the basis that countervailing considerations, such as the need to protect the privacy rights and dignity of the complainant, outweigh the tenuous connection the evidence has to the accused's ability to make full answer and defense. With these points in mind, when applying this regime, trial judges must take a careful, rigorous approach, one that recognizes and protects against the risks that accompany sexual activity evidence. The statutory requirements set out in Section 276 sub 2 are designed to ensure that any admissible sexual activity evidence is limited in scope and that its legitimate purpose is identified and weighed against countervailing considerations. A careful application of these requirements is essential to the integrity of the trial process. The integrity of the trial process can be further protected by adopting certain best practices for communicating general relationship evidence, such as the kind sought to be adduced in this case, after an admissibility ruling has been made. As the Attorney General for Ontario, AGO, suggested in its intervenor submissions before this court, where general relationship evidence is ruled admissible under Section 276 sub 2, the party should reduce that evidence to a clear and concise agreed statement of facts prior to trial. This statement would ensure that the evidence elicited at trial does not stray beyond the parameters of the trial judge's ruling. Alternatively, the trial judge has the discretion to permit Crown and Defense Counsel to lead the complainant and the accused, respectively, through an accurate description of their relationship. These simple, prudent practices can go a long way to ensuring the scope of sexual activity evidence elicited at trial goes no further than necessary, thereby safeguarding the privacy rights and dignity of the complainant, preserving the integrity of the trial process, and promoting the search for truth. Furthermore, where sexual activity evidence has been ruled inadmissible under Section 276 sub 2, all trial participants, including the trial judge, Crown and Defense Counsel, and witnesses, must hew to the specific, legitimate purpose for which the evidence has been admitted, without expanding the scope of the ruling or using the admissible evidence for inadmissible purposes. Any new basis for admissibility that emerged during the course of the trial should be the subject of a fresh Section 276 application. And when sexual activity evidence is ultimately elicited at trial, it should be followed swiftly by a mid-trial limiting instruction to the jury that identifies both the permissible and impermissible uses of the evidence. This instruction should be reinforced by a final jury instruction. In short, everyone must get crystal clear and remain crystal clear about why evidence is being admitted. With these principles in mind, I will now consider whether the trial judge in this case erred by admitting the friends with benefits evidence under Section 276. Subpart B. Application of Section 276. The determination of whether sexual activity evidence is admissible under Section 276 raises a question of law. A ruling on this matter is therefore reviewable on a standard of correctness. To determine whether the trial judge erred in this case, we must consider the facts as known to her at the time of the voir dire. In his affidavit filed in support of his application under Section 276.1, Mr. Goldfinch stated that after their breakup, he and the complainant would get together at his residence to have sexual intercourse. He also noted that they both referred to this relationship as a friends with benefits arrangement. At the Section 276.2 voir dire, Mr. Goldfinch argued that evidence of the sexual nature of their relationship was necessary to provide proper context and to avoid leaving the jury with the erroneous impression that after the complainant and he ceased living together, they maintained a purely platonic friendship. In conducting the Section 276 voir dire, the trial judge was required to first consider Section 276 sub 1 and then ask whether, in light of the basis for admission set out in Mr. Goldfinch's application, the proposed evidence satisfied the three requirements set out in Section 276 sub 2, taking into account the factors listed in Section 276 sub 3. I will consider and apply these provisions in turn, keeping in mind that the analysis must remain fixed at the time of the voir dire. Before commencing this analysis, I note that the relationship evidence sought to be adduced in this case, evidence of a friends with benefits relationship involving occasional sex, directly implicates sexual activity and is therefore subject to the Section 276 regime. Whether general evidence of categories of relationships that may or may not involve sexual activity, such as marriage, dating, etc., might also engage Section 276 is not before the court. I would therefore leave that issue for another day. That said, without finally deciding the matter, I am inclined to view that such evidence would not, without more, engage Section 276, as it does not amount to evidence that the complainant has engaged in sexual activity. Of course, if the accused were to seek to go into details about the relationship revealing that the complainant has engaged in sexual activity, for example, evidence that the accused and the complainant were in a spousal relationship involving regular sex, then that evidence would have to pass through the Section 276 filter. 1. Section 276 sub 1. As indicated under Section 276 sub 1, sexual activity evidence cannot be admitted to support the inference that, by reason of the sexual nature of the activity, the complainant was more likely to have consented to the sexual activity forming the subject matter of the charge, or is less worthy of belief. In this case, as I have explained, Mr. Goldfinch sought to tender evidence that at the time of the alleged sexual assault, he and the complainant maintained a friends with benefits relationship that involved occasional sex. On its face, this evidence could potentially be used to support the first of the twin myths. The myth that because the complainant consented to have sex with Mr. Goldfinch in the past, she was more likely to have consented to the sexual activity forming the subject matter of the sexual assault charge. However, Section 276 sub 1 takes this potential use off the table. As such, unless Mr. Goldfinch could point to some legitimate use of the sexual activity evidence that would justify admission, that evidence was inadmissible. To determine whether a legitimate use justifying admission existed, we must turn to Section 276 sub 2. 2. Section 276 sub 2. Section 276 sub 2 provides that in order to be admissible, sexual activity evidence must a. be of specific instances of sexual activity, b. be relevant to an issue at trial, and c. possess significant probative value that substantially outweighs the danger of prejudice to the proper administration of justice. I will consider and apply these requirements in turn. A. Specific instances of sexual activity. The first requirement of Section 276 sub 2 is that the evidence be of specific instances of sexual activity. In L.S., the Ontario Court of Appeal considered whether relationship evidence could satisfy Section 276 sub 2 sub A's specificity requirement. In that case, the complainant and the accused were in a spousal relationship. The complainant alleged that the accused sexually assaulted her. The accused applied to introduce evidence of the nature of his relationship with the complainant under Section 276. The affidavit filed in support of his application stated that he and the complainant were together as a couple for the entire year of 2009 and that they had an active sex life for that year in which they had sex on a regular basis. Justice Doherty, writing for a unanimous panel, held that despite the absence of specific features of the sexual activity or individualized instances of sexual activity in the accused's affidavit, the evidence nonetheless satisfied the specific instances requirement under Section 276 sub 2 sub A. He reasoned that the content of the specific instances requirement is linked to the nature of the evidence sought to be adduced. Where the accused seeks to introduce evidence of an individual instance of sexual activity, he must specify that instance with specificity. By contrast, where the accused seeks to introduce general evidence that describes the nature of the relationship between the accused and the complainant, the specificity requirement speaks to factors relevant to identifying the relationship and its nature, and not to details of specific sexual encounters. These factors will include the parties to the relationship, the relevant time period, and the nature of the relationship. I would adopt Appeal Justice Doherty's interpretation of Section 276 sub 2 sub A, insofar as it relates to evidence of the nature of the relationship between the complainant and the accused before, at the time of, and after the sexual activity forming the subject matter of the charge. Here, Mr. Goldfinch's affidavit specified the parties to the relationship, himself and the complainant, the relevant time period, subsequent to their breakup in 2012 until the alleged sexual assault in May 2014, and the nature of the relationship, friends with benefits. Therefore, the trial judge was correct in her conclusion that Mr. Goldfinch discharged the requirement under Section 276 sub 2 sub A that the evidence be of specific instances of sexual activity. B. Relevant to an issue at trial. The second requirement of Section 276 sub 2 is that the evidence be relevant to an issue at trial. To fulfill this requirement, the accused must establish a connection between the complainant's sexual history and the accused's defense. Here, Mr. Goldfinch argued that the threshold for relevance was met because the friends with benefits evidence, 1, was necessary to avoid an erroneous misapprehension on the part of the jury that he and the complainant were platonic friends at the time of the alleged sexual assault, and 2, provided context to the issues at trial. I will consider each argument in turn. By way of background, at the voir dire stage, Crown Counsel proposed a statement of facts that did not include the existence of a friends with benefits relationship between Mr. Goldfinch and the complainant. Instead, the proposed statement of facts stated that Mr. Goldfinch and the complainant had previously been in a romantic relationship for 7 or 8 months, during which time they lived together. It further stated that they were friends at the time of the events in question, and the complainant sometimes spent the night at Mr. Goldfinch's residence. The problem with the first rationale advanced by Mr. Goldfinch is that it does not explain why it would be necessary to correct any potential misapprehension as to the sexual nature of his relationship with the complainant. A judge reviewing Mr. Goldfinch's application might legitimately conclude that the friends with benefits evidence was being proffered solely to inform the jury that the two were occasionally engaging in sexual intercourse during the relevant time frame, and to potentially support the impermissible inference that it was more likely that the complainant consented on the night in question. If this was the sole reason for which the defense sought to correct the supposed misapprehension, then the evidence was inadmissible by virtue of Section 276 sub 1. Assuming, however, that there may have been a legitimate reason to correct any potential misapprehension on the part of the jury, Mr. Goldfinch's application did not identify one. As for the second rationale, Mr. Goldfinch argued that the sexual activity evidence was relevant to his defense because it provided context to the events that formed the subject matter of the sexual assault charge. The trial judge described the existence of an ongoing sexual relationship between the complainant and Mr. Goldfinch as a background piece of evidence that the jurors could use when assessing the conflicting direct evidence as to whether or not the complainant did consent to the events in question. In my view, this line of reasoning paints too broad a brushstroke. While it is true in every case that the existence of a friends with benefits relationship between the complainant and the accused provides context to the events at issue, neither Mr. Goldfinch's vaguely drafted affidavit nor his arguments at the voir dire stage specified the precise inference he wanted the jury to draw from that context. Put differently, he failed to identify a specific, legitimate purpose for putting the friends with benefits evidence before the jury. He did not link the evidence to specific facts or issues relating to his defense that could be properly understood and resolved only if reference could be made to the friends with benefits evidence. Where sexual activity evidence is concerned, the failure to identify the explicit link between the evidence and specific facts or issues relating to the accused defense can result in twin myth reasoning, slipping into the courtroom in the guise of context. For example, there is a risk that sexual activity evidence may be used, whether consciously or not, to contextualize a complainant's testimony that she did not consent to the sexual activity in question through twin myth reasoning. Because the complainant consented in the past, the context, it is more likely that she consented this time as well. This is, of course, precisely the sort of stereotypical reasoning Section 276 sub 1 sought to banish from the courtroom. Yet without a clear and precise identification of the specific purpose for which sexual activity evidence is sought to be introduced, this sort of reasoning can all too easily infiltrate the courtroom through the Trojan horse of context. In sum, the context rationale offered by Mr. Goldfinch was insufficient to satisfy Section 276 sub 2 sub b. In my respectful view, any conclusion to the contrary would open the door to the admission of sexual activity evidence in every case where the complainant and the accused were in a previous or ongoing sexual relationship, so long as the accused cites the need for greater context in his application. This cannot have been Parliament's intent. The words context and narrative do not, in my view, offer the accused a means of bypassing the measured analysis required by Section 276. Thus, the key flaw in Mr. Goldfinch's application was his failure to identify specific facts or issues relating to his defense that could be properly understood and resolved by the trier of fact only if reference was made to the friends with benefits evidence. Some discussion of what I mean by specific facts or issues relating to the accused defense may prove helpful. As I will develop, without reaching any final decision on the matter, I note that in this case, there was at least one specific issue that Mr. Goldfinch could have referred to in his application that might have properly supported admission of the friends with benefits evidence. The jury's assessment of Mr. Goldfinch's testimony that he mouthed the words, quote, "I'm going to fuck you," to the complainant shortly before they went downstairs. In discussing this example below, I should not be taken as foreclosing the possibility that additional facts or issues relating to Mr. Goldfinch's defense may be identified at the new trial that might support the admission of the friends with benefits evidence. When explaining the events leading up to the sexual activity forming the basis of the sexual assault charge, Mr. Goldfinch testified as follows. Quote, "Well, we went downstairs, the complainant and I. I had asked her to come downstairs with me. Prior to that, we were talking and joking around and everything, getting along very well upstairs, and I kind of mouthed to her, 'I'm gonna fuck you,' and she smiled, gave me a little cute smile back." End quote. Evidence that the complainant and Mr. Goldfinch were in a friends with benefits relationship at the time of these events may have provided necessary context to aid the jury in assessing Mr. Goldfinch's testimony that he mouthed the words, quote, "I'm going to fuck you," to the complainant. If the jury lacked the knowledge that the two were in a sexual relationship at the time, this statement by Mr. Goldfinch might have seemed bizarre or even menacing. Furthermore, Mr. Goldfinch's testimony that he made this statement to the complainant may itself have seemed implausible. In this way, withholding the friends with benefits evidence from the jury could have led them to make an adverse credibility determination against Mr. Goldfinch that they otherwise would not have made. A jury's determination of which witnesses to find credible is a holistic exercise that involves assessing the plausibility and coherence of a given witness's testimony throughout the course of the trial. Withholding the sexual nature of Mr. Goldfinch's relationship with the complainant could have had an adverse impact on the jury's assessment of Mr. Goldfinch's credibility, potentially infringing upon his right to make full answer and defense. To be clear, however, just as generic references to context or narrative will not suffice to justify the admission of sexual activity evidence under Section 276 sub 2, bare invocations of credibility will not be enough. Credibility is a key issue in almost every sexual assault trial. The centrality of credibility assessments does not, however, allow the accused to bypass the rigors of Section 276. Instead, where credibility is concerned, the accused must identify specific facts or issues that require reference to the sexual activity evidence to be understood and that could have a material impact on a credibility assessment. Returning to the case at hand, Mr. Goldfinch might have been able to establish a legitimate link between the friends with benefits evidence and his credibility by pointing to the need to enable the jury to properly assess his testimony that he mouthed the words, "I'm going to fuck you," to the complainant. Had Mr. Goldfinch referenced this aspect of his anticipated testimony in his 276 application, the trial judge would have been better equipped to engage in the balancing exercise required by Section 276 sub 2 and sub 3. Indeed, she may have properly determined that the friends with benefits evidence was admissible for the narrow purpose of allowing the jury to assess Mr. Goldfinch's testimony on this point. She may have further found that the impact on the complainant's privacy rights and dignity would be limited, as the bare fact that Mr. Goldfinch and the complainant were in a friends with benefits relationship at the time of the alleged sexual assault would be unlikely to unduly arouse the jury's sentiments and would not require a sweeping and prejudicial inquiry into the complainant's sexual history. She may have also determined the admission of the evidence was necessary to ensure Mr. Goldfinch's right to make full answer and defense. Be that as it may, the fact remains that in this case the friends with benefits evidence was admitted for a different and much broader purpose. It was ushered into the courtroom under the broad banner of context, without any identification of the specific facts or issues relating to Mr. Goldfinch's defense that required reference to this context to be properly understood and resolved. In short, Mr. Goldfinch's application lacked the specificity and precision required to justify admission of the evidence in question. For these reasons, I conclude that Mr. Goldfinch's Section 276 application did not satisfy the relevant to an issue at trial requirement under Section 276 sub 2 sub b. Accordingly, it ought to have been denied. C. Probative value versus potential prejudicial effect. The third requirement of Section 276 sub 2 is that the evidence have a significant probative value that is not substantially outweighed by the danger of prejudice to the proper administration of justice. As this court explained in Derich, the requirement of significant probative value serves to exclude evidence of trifling relevance that, even though not used to support the two forbidden inferences, would still endanger the proper administration of justice. Evidence that is not relevant under Section 276 sub 2 sub b is necessarily incapable of possessing any probative value, as the concept of probative value presupposes that the evidence bears on a relevant issue. Thus, given my conclusion that the sexual activity evidence in this case was not relevant to an issue at trial based on the application presented to the trial judge, I conclude that the evidence was incapable of satisfying the third requirement under Section 276 sub 2. That said, in the interest of providing further guidance, I will briefly explain why the lack of specificity in Mr. Goldfinch's application also adversely impacted the trial judge's ability to balance the probative value of the evidence against its potential prejudicial effect as required by Section 276 sub 2 sub c. To enable the trial judge to properly assess whether sexual activity evidence sought to be adduced has significant probative value that substantially outweighs its potential prejudicial effect, the accused must situate the evidence within the particular factual matrix of the case at hand. It is only through awareness of specific facts or issues that require the admission of the evidence that the trial judge can determine whether the danger of prejudice to the proper administration of justice presented by the evidence is outweighed by its probative value. The trial judge tasked with performing this balancing exercise will not be aided by generic references to context, narrative, or potential misapprehensions. More is needed. This conclusion is underscored by the fact that the trial judge must consider a number of factors under Section 276 sub 3 when making a determination under Section 276 sub 2. These factors are specific in nature and require that the trial judge be in a position to evaluate the precise impact that the exclusion of the evidence would have had on the accused's ability to make full answer and defense. The accused must provide the trial judge with the necessary tools to perform this inquiry, including a precise and clearly articulated connection between the sexual activity evidence and specific facts or issues relating to his defense. Unfortunately, that was not done here. D. Conclusion on admissibility. For these reasons, although Mr. Goldfinch's application satisfied the specific instances of sexual activity requirement under Section 276 sub 2 sub a, it satisfied neither the relevance requirement under Section 276 sub 2 sub b, nor the balancing exercise required by Section 276 sub 2 sub c. As such, it was a legal error for the trial judge to admit the sexual activity evidence under Section 276 sub 2. In light of this conclusion, it becomes necessary to consider whether the trial judge's error warrants a new trial. Subpart C. Whether a new trial is warranted. Under the test articulated in the Queen engraved line, an acquittal will be overturned only where the Crown can demonstrate that the trial judge made a legal error that might reasonably be thought, in the concrete reality of the case at hand, to have had a material bearing on the acquittal. For reasons that follow, I am satisfied that the improper admission of the Friends with Benefits evidence meets this test. 1. The trial judge's limiting instructions. An important feature of the Section 276 regime is its requirement of mandatory limiting instructions. Section 276.4 provides that where sexual activity evidence is admitted pursuant to Section 276 sub 2, the judge shall instruct the jury as to the uses that the jury may or may not make of that evidence. In this case, while the judge's limiting instruction cautioned the jury not to use the evidence of the sexual nature of Mr. Goldfinch's relationship with the complainant to support either of the twin myths, the instructions did not identify any permissible use of this evidence. The trial judge's final instruction to the jury on this point was as follows. Quote, "You heard some evidence that Mr. Goldfinch and the complainant had dated, briefly lived together, and continued to have sexual relations on occasion in 2014. This evidence provides you with some context for their relationship. You must not use this evidence, however, to help you decide or infer that because of the sexual nature of their relationship, the complainant is more likely to have consented to sexual intercourse with Mr. Goldfinch on May 29, 2014. Further, you must not use the evidence of their relationship to help you decide or infer that the complainant is less believable or reliable as a witness in this case." End quote. This instruction successfully identified the twin myths and cautioned the jury not to rely on them. However, the trial judge's statement that the evidence provided the jury with some context for their relationship was insufficient. The instruction did not identify any specific use to which the jury could properly put the evidence. As a result, the jury was left in the dark about how they could use the evidence. 2. Other sexual activity adduced at trial. As indicated, the trial judge's instructions to the jury failed to identify specific facts or issues to which the sexual activity evidence related. Moreover, compounding the risk of forbidden reasoning based on discriminatory generalizations, the trial judge admitted evidence of the complainant's sexual activity going beyond the scope of her initial Section 276 ruling. I note at the outset of this discussion that both the Crown and defense were responsible for adducing sexual activity evidence that went beyond the scope of the trial judge's ruling. In my view, the fact that both defense and Crown counsel strayed beyond the boundaries of the judge's ruling further illustrates the insufficiency of that initial ruling. Because the judge admitted the friends with benefits evidence under the broad banner of context, the parties were left without any clear guidance on what other pieces of sexual activity evidence might be admissible under this broad banner. They may well have thought that the door had been swung wide open on sexual activity evidence, because all such evidence would provide context to the events at issue in a general sense. Therefore, the overbreadth and irrelevance of the sexual activity evidence adduced at trial should serve as a cautionary tale of what can go wrong when the Section 276 regime is not properly observed. At trial, both the complainant and Mr. Goldfinch were questioned about sexual activity that went beyond the scope of the Section 276 ruling. The trial judge initially determined that the only evidence which was admissible under Section 276 sub 2 was the fact that the complainant and Mr. Goldfinch were in a friends with benefits relationship. However, at trial, defense counsel cross-examined the complainant about how many times she had sex with Mr. Goldfinch following their breakup. This directly contravened one of the bases for the trial judge's ruling, namely that any prejudice to the complainant's privacy rights and dignity would be minimal, because she would not be asked about the particulars of her sexual history with Mr. Goldfinch. That the complainant was ultimately asked about such particulars on cross-examination constituted a significant infringement of her privacy rights and dignity. Furthermore, defense counsel asked the complainant about other partners she may have had at the time she and Mr. Goldfinch were in a friends with benefits relationship. She testified that she had a sexual partner other than Mr. Goldfinch at the time. This evidence ran a serious risk of distorting the jury's fact-finding process by inviting stereotypical reasoning about women and consent, such as the myth that women who are unchaste are more likely to consent. I note that the defense did not apply to have the trial judge revisit her initial Section 276 ruling before eliciting this evidence. As such, the evidence was not the subject of a limiting instruction. The Crown also strayed beyond the bounds of the trial judge's ruling. It is true that the Crown is not subject to the procedural requirements of subsections 276.1 and 276.2, which apply only when the accused seeks to adduce evidence of the complainant's other sexual activity. However, the Crown is subject to Section 276 sub 1's prohibition on twin myth reasoning, and must also abide by the common law principles articulated by this court in Seaboyer. Indeed, in the Queen and Barton, this court stated that trial judges should determine the admissibility of Crown-led prior sexual activity evidence through a voir dire prior to trial, applying this court's guidance in Seaboyer. No such procedure was observed here. During direct examination of the complainant, Crown Counsel elicited testimony that made reference to the complainant's other sexual partner. Further, in the Crown's cross-examination of Mr. Goldfinch, counsel led Mr. Goldfinch to provide details of his sexual routine with the complainant, namely, that they would generally have sex when the complainant stayed over at his house. This was prejudicial information about other instances of sexual activity by the complainant and should have been the subject of its own voir dire and ruling. For reasons of procedural fairness, the fact that the Crown strayed beyond the bounds of the trial judge's ruling and elicited additional sexual activity evidence that was not the subject of a voir dire clearly cannot be used as a basis for setting aside Mr. Goldfinch's acquittal. Put simply, the Crown cannot be permitted to benefit from its own missteps. Nevertheless, much of the improper evidence was led by the defense. This resulted from the erroneous admission of the friends with benefits evidence under the broad banner of context. In these circumstances, the public interest in a trial that is conducted properly according to the law and the need to protect the integrity of the justice system militate in favor of a new trial. I would add that, as the AGO points out, vetting sexual activity evidence advanced by either Crown or defense before trial will have the salutary effect of focusing all parties on the legitimate use of such evidence. This approach will also establish the parameters of any sexual relationship evidence that the Crown seeks to adduce, and trigger defense counsel to bring a separate application under Section 276 sub 2 if they wish to elicit evidence going beyond the scope of that proposed by the Crown. The failure to do so here led to the unnecessary and inappropriate admission of sexual activity evidence that went beyond the trial judge's Section 276 ruling. This evidence came in without first having been vetted, and it was never the subject of its own limiting instruction. This was a serious error. To be clear, I make no final determination as to whether any evidence going beyond the bare fact that Mr. Goldfinch and the complainant were friends with benefits at the time of the alleged sexual assault might ultimately be found admissible at a new trial where it is subject to proper vetting. Here, I simply point out the overbreadth of the sexual activity evidence elicited at trial as a means of illustrating the adverse impact that an improper admissibility determination under Section 276 can have on the integrity of the trial process. This case serves as a powerful illustration of how a trial can go off the rails where sexual activity evidence is admitted without being anchored to a specific legitimate purpose. Without this anchor, the trial judge may drift into unsafe waters, as occurred in this case. And while the trial judge in this case made an effort to mitigate the situation, the damage was already done. Mr. Goldfinch's application should not have been allowed in the first place. In conclusion, the errors at trial stemmed directly from the trial judge's improper Section 276 ruling, which allowed for the admission of sexual activity evidence under the broad banner of context. Grounded in this ruling, the trial judge's flawed limiting instructions failed to demonstrate how the sexual activity evidence was capable of assisting the jury to resolve specific facts or issues relating to Mr. Goldfinch's defense. This flawed instructions distorting effect was compounded when additional sexual activity evidence was admitted at trial, which was not the subject of its own admissibility determination or limiting instruction. The cumulative impact of these errors, in my view, can reasonably be thought to have had a material bearing on Mr. Goldfinch's acquittal. Accordingly, I agree with the Court of Appeal that a new trial should be ordered. Part 5. Conclusion. In the result, I would dismiss the appeal.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.